The lawsuit became famous as the case of a $54 million pair of pants. But the court never found that any pants were worth anything close to that. Roy Pearson demanded millions after a dry cleaner returned trousers he said were not his, while the cleaners insisted the disputed pair had been his all along. The cleaners had a sign saying, "Satisfaction guaranteed," and Pearson argued that those two words gave the customer the power to decide what satisfaction required. So, the real question was not how expensive one pair of pants could be, but whether a simple store sign could create an unlimited legal obligation. Pearson was not an ordinary customer wandering into an unfamiliar shop. He was an attorney who had used custom cleaners in Washington, D.C. for years. In 2002, the cleaners had temporarily been unable to locate another pair of his pants. After a dispute over value, Pearson received $150. The amount he said replacement would cost. That earlier incident later became important because it showed both that disputes had happened before and that the cleaners had at least once paid him. 3 years later, Pearson had just taken a District of Columbia government job that required him to wear a suit. He brought several pairs of trousers to custom cleaners for alterations over a short period. One claim ticket covered pants that Pearson said belonged to an expensive Hickey Freeman suit with burgundy and blue pinstripes. He wanted the waist let out and needed the pants back quickly. When the promised pickup time arrived, the pair was not ready. Pearson testified that Soo-chung gave changing explanations, including that the trousers had been sent to another store by mistake. Days later, the cleaners produced a pair of gray trousers that Soo-chung said were his. Pearson rejected them. He said the trousers had cuffs, that he did not wear cuffed suit pants, and that they did not match the jacket he said belonged with the missing pair. Soo-chung gave a very different account. She said she recognized the disputed trousers because she had altered them herself, and because they had unusual elastic belt inserts. The cleaners also pointed to a red tag on the trousers bearing the same number as the tag associated with Pearson's claim ticket. That turned a missing clothing dispute into a factual problem with evidence on both sides. But Pearson did not keep the case at the value of a suit. He initially demanded $1,150. Then filed claims under the district's consumer protection law and common law theories, including fraud. As the litigation expanded, so did the damages. By the joint pre-trial statement, his theories produced a demand exceeding $67 million. By the time of trial, the figure widely reported and associated with the case had been reduced to $54 million. The number came from multiplying statutory theories. Defendants, alleged violations, signs, days of display, and requested damages rather than from any claim that the cloth itself was worth $54 million. Pearson also claimed large sums for emotional distress, rental car expenses, and hundreds of thousands of dollars for the time he said he had spent working on the case. The cleaner's window had become a damages calculator, which is not normally how dry cleaning works. Still, an enormous demand does not automatically make the underlying legal issue meaningless. The District of Columbia's Consumer Protection Procedures Act prohibits deceptive and misleading trade practices, and a merchant's advertising can create real liability. Pearson's central theory focused on the words "satisfaction guaranteed." He argued that the phrase was unconditional, and that satisfaction was determined by the customer. Under his position, if the customer remained dissatisfied, the merchant had to provide whatever lawful compensation the customer demanded. At trial, that theory was pushed to its logical edge. Pearson acknowledged that under his interpretation, even a customer the cleaner believed was mistaken or lying could still demand payment under the guarantee. The later disciplinary record noted that he accepted the implication that the demanded amount could even be extravagantly high. The Chung's answer was much narrower and much more familiar. Su Chang testified that satisfaction guaranteed meant the shop would try to correct a cleaning or alteration problem, and if it could not, reasonably compensate the customer for the item. Other customers testified that they understood the sign in essentially that practical way. That distinction mattered because consumer law does not normally read advertising by asking what the most aggressive possible reader can force the words to mean. The trial court looked to how a reasonable consumer would understand the sign. Under that approach, satisfaction guaranteed was not a blank check controlled solely by one customer's subjective demand. Pearson had another advertising theory based on a same-day service sign. He treated the sign as a promise that any requested service had to be completed the same day. But he presented no evidence that custom cleaners did not make same-day service available when appropriately requested. He also acknowledged that he himself had never requested same-day service. The appellate court later said his automatic, unlimited interpretation of that sign simply did not make sense. The factual dispute over the pants remained separate from the dispute over the signs. To win the fraud and relevant consumer protection claims, Pearson had to meet a demanding, clear, and convincing evidence standard. He needed more than a sincere belief that the returned trousers were wrong. He had to prove the facts supporting deception and the statutory violations. Judge Judith Bartnoff found Su Chang's testimony very credible. The judge accepted that the disputed pants did not appear to match the jacket Pearson brought to court, and accepted that he disliked cuffs. But those facts did not establish that the cleaners had substituted someone else's trousers. The unusual belt inserts, the tag evidence, the number of pants Pearson had recently handled, and Su Chang's account gave the court substantial reasons to doubt his theory. The judge found her explanation more credible than Pearson's speculation that she had taken unclaimed pants and altered them to fit him. That finding was devastating, because the pants-related claims depended on proving that the cleaners had actually lost his trousers and tried to pass off another pair. He did not carry that burden. The sign claims failed for a second reason. The evidence did not show that the Chongs had posted satisfaction guaranteed while secretly intending not to honor it. In fact, Pearson's own 2002 experience cut against him, because the cleaners had paid him the replacement value he requested when another pair could not be found. The strongest evidence in his own history with the store therefore helped the defense on intent. Pearson's case also faced a basic limiting principle problem. If one unhappy customer alone could define satisfaction and dictate any amount of compensation, the sign would effectively transfer control of the merchant's liability to whoever made the demand. The appellate court later observed that Pearson had no pertinent authority for that interpretation. It held that the trial judge had correctly applied a reasonable consumer approach instead. The result was complete at the trial level. Pearson recovered nothing on the claims that went to judgment. The Chongs won. That did not mean the court proved with mathematical certainty that the disputed trousers were Pearson's. It meant Pearson failed to prove under the governing burden that the trousers offered back to him were not the ones he had delivered. That distinction matters because losing a civil claim is not the same thing as having every factual possibility disproved. Pearson appealed. He argued that the trial court had misapplied the law, and also challenged the denial of his late request for a jury trial. In December 2008, the District of Columbia Court of Appeals affirmed the judgment. The appellate court agreed that the satisfaction guaranteed sign could not reasonably be read as an unlimited promise to satisfy any demand selected solely by the customer. It also upheld the rejection of the same-day service claim, because Pearson had not shown that same-day service was actually unavailable. On the pants themselves, the appellate court agreed that Pearson had not met his burden. His jury trial argument failed too. Pearson had not demanded a jury within the normal deadline, and the trial court had discretion over his later request. The appellate court found no abuse of that discretion. So, the $54 million case ended with $0 awarded to Pearson. The Chungs had made 3 formal offers of judgment during the litigation, with the largest at $12,000, and Pearson rejected them. After winning, the Chungs pursued a motion that could have shifted attorneys' fees, costs, and sanctions to Pearson. They later withdrew that request after public fundraising had covered their legal expenses, hoping the dispute would finally end. The motion had included a request approaching $100,000 in attorney's fees. That was not an award Pearson was ordered to pay, and it should not be confused with the damages he had demanded. The strangest legal afterlife came years later. The litigation itself became the basis of attorney discipline proceedings against Pearson. In 2020, the District of Columbia Court of Appeals concluded that he had violated professional rules against frivolous claims and serious interference with the administration of justice. The court emphasized that aggressive or creative arguments are not automatically unethical, even when they are unlikely to succeed. The line was crossed, it said, because Pearson continued advancing liability and damages theories that a reasonable attorney could not regard as having even a faint hope of success. The disciplinary court also relied on his repetitive and burdensome litigation tactics and his repeated mischaracterizations of legal authorities and procedural facts. It ordered a 90-day suspension from the practice of law in the District of Columbia. That later ruling is important because it corrects another easy simplification. The original lawsuit was not automatically sanctionable, merely because the demand looked absurd, or because Pearson lost. Lawyers are allowed to test uncertain law and make ambitious arguments. What became professionally punishable was the continued pursuit of theories the disciplinary court found objectively frivolous, combined with conduct that seriously burdened the judicial process. And the original consumer law ruling was narrower than the headline suggested. It did not hold that satisfaction guaranteed is meaningless. It did not give businesses permission to make promises they never intend to keep. It held that ordinary advertising language is interpreted in context through reason and evidence, rather than as an unlimited transfer of power to the most dissatisfied customer. The same is true of the pants. The court did not need to declare that Pearson had imagined the entire dispute. It needed to decide whether he had proven the legally necessary facts, and it concluded that he had not. So, the famous $54 million pants were never really a $54 million piece of clothing. They were the vehicle for a much larger claim that 2 words on a shop sign could make the customer the final judge of both satisfaction and price. The courts rejected that theory because a guarantee can create obligations without becoming a blank check.